Hey guys, it's Karalynn and welcome back to the podcast. And today we're going to talk about like every contractor's nightmare. What happens if I get sued? Am I going to go out of business? I'm going to lose all my assets. What does it look like? And actually, what are my options? And today, discuss this with me is Jess from our lien and collections department, who's also been very involved in litigations and helping contractors when they get sued. Welcome to the show, Jess.
Thank you. So let's start. Let's say I'm a subcontractor and I just got served with a lawsuit. What do I do?
Okay, the first thing you do is breathe, right? It's not the end of everything. It is intense. It is a lot. It's scary because you don't know what's going to happen, right? So the first thing is breathe. Second thing is don't ignore it, right? Don't put it in a stack of paperwork that you never get back to, because what can happen is if you don't answer the lawsuit, the other side can win by default, meaning you didn't show up, so the other side gets a judgment for everything they're asking for just because you didn't show up. And what that looks like is all of a sudden your bank account's garnished and you don't know why. So first thing, don't panic. Second thing, don't ignore it, right? So you get the lawsuit. The next thing you're going to do is go back into your files and get everything you can find, right? And generally speaking, a fight normally does not just start with a lawsuit, right? There's normally a demand letter beforehand that probably got ignored, right? And so my other advice is if you get that demand letter from an attorney, don't ignore it.
So what if they don't send me a demand letter?
Okay, so then they've sued you, right? And so in some situations, they can't do that, right? So it's a great topic for residential contractors. In Texas and most other states, there's a process a homeowner or a property owner has to do before they can sue you, right? And it's in Texas, it's called RECLA, right? They have to give you a list of defects and a chance to cure. If they don't do that, then you can stop the lawsuit to take the time to do that. But most other claims, like a breach of contract that's not related to, construction, can go or in a commercial project can go forward even if they didn't send a demand letter. So it kind of depends.
Not getting paid on a job you already completed? Well, that's where we come in. At the Karalynn Law Firm, our lien and collection department helps you get paid fast and the right way. You did the work, you deserve to get paid. We help you take the right legal steps by filing liens and collecting the money that's owed. Contact us at 713-715-7334, or you can visit our website at www.thekrominslawfirm.com.
But so you get served with a lawsuit, you're going to go gather up everything you can find, right?
What's my deadline?
Oh, okay. So generally speaking, in Texas and most other states, it's either 30 days or under. So like in Texas, it's the first Monday after the expiration of 20 days. So if you just said 20 days, you'll be fine. Just peace court is faster. It's 14 days. So if you're sued in like a JP court, your answer is due faster, right? And so, and the thing is that once litigation goes slow once you file that answer. If you don't file that answer, it will go fast and the judgment will be taken against you, right? So don't ignore it. Gather everything. Go talk to a construction attorney and lay out the facts.
You said default judgment. What is a default judgment exactly?
So it's a judgment against you just by your failure to appear. And it's, an official court judgment, which, like, if you find out about it in the first 30 days, it's relatively easy to deal with. If not, it will be very difficult to deal with. And basically, now your assets are up for collection, whether it's, and I don't know if they sued you personally or sued just the company. They can garnish bank accounts. They can go after equipment, all based on this judgment. So it's very important that you file an answer.
When can they file suit against me personally?
Okay, so a lot of attorneys, as a tactic, will sue somebody personally, even if they don't have real grounds in the initial lawsuit, right? And so, like, if you don't answer when they sue you personally, even though you may have a defense to the personal liability, now they have a judgment against the company and the individual, which is even more dangerous. There are certain instances where you can truly be sued individually. The first one, and kind of the most common one that people take for granted, is if you're an LLC in Inc., but you let your Inc. expire because you didn't file the proper paperwork with the Secretary of State, and they kill your entity, and you don't know about it. They'll probably send you something in the mail that your entity is now basically expired because you didn't file your annual report. And so if that happens, you can be sued individually. In construction, there's also what's called trust fund violations. And so the idea behind trust funds is that anyone who receives funds on a construction project, if they owe money to people who did work or provided material or labor, those people have got to be paid first before they do anything else with the money. And so if somebody can prove or has an idea that instead of taking those trust funds and paying everybody, the contractor or the owner went out and bought a truck or went on vacation or something like that, there is individual liability for that.
So let's say I got sued, but neither one of us has a written contract.
Oof. That's a hard case, right? Because
it happens all the time.
I know. And talk about one of the most expensive cases.
Exactly.
Because now I got to be like, okay, what evidence do I have of what the agreement is? The other side's going to say it's something different. I'm going to say something, and the case is going to take forever because there's no way out except going for trial or settlement because I got no documents, right? That's a very hard case to prove.
What can I use as evidence at that point?
Text messages, emails, pictures of the work that you actually did, anything like that would be helpful to kind of prove what you were hired to do.
I think that's one thing how often do you tell clients it's okay to take pictures of the job sites?
All the time. I mean, actually, they should be doing it on the daily, right? Like a lot of these
progress.
Yeah, well, like a lot of these CRMs and now that contractors should be using, like DropTread, have a place where they would upload it into their platform. So it's there for their records in the future, but also the client can see what's going on. Hopefully litigation doesn't happen, but if it does, some of the best evidence is pictures or evidence of things that were going on before there was a dispute. That's truly the best evidence.
So the progress of the job.
Correct.
I think that's what we always, day by day.
Correct.
What is one big mistake that you say happens when somebody's being sued?
Well, the first thing, do not destroy anything, right? Don't go in and delete all the emails even because you think they look bad. It will be worse than whatever happened if you delete those emails and they can prove it, right? You can get sanctioned. You can, basically you can lose by default even though you're there if they can prove there was evidence that you destroyed. So keep everything, whether you think it's helpful or not. Don't, like I said, don't delete things. Take everything, what I always tell my clients is even if they have a client that they think is unhappy or they got an email that they're unhappy, it's like at that point, if you don't have a CRM that has daily reports or anything, make a chronological timeline of events of how you remember them happening because memories fade, especially like a breach of contract claim is 4 years, right? So 4 years later, they could come back and sue you.
Oh, I think we've seen some of those where, okay, let's talk about one we just had a few weeks ago. Our sub was working for a GC. They did a house. I think it was literally about to hit the 4-year mark, and he got sued.
Yes.
But at that point, everybody got sued.
True. I mean, that happens. And so, right, and at that case, there were some very specific damages, but they sued everyone, which kind of happens, especially on a commercial project, because they can get money out of everyone just to get out of the lawsuit, not that you actually did anything wrong.
So I have insurance. My insurance is going to cover this? Okay. Or am I going to have to pay your attorney fees?
Great question. Great question. Okay, so let's start with the general rule that insurance does not cover bad work, right? So if you mess something up, the insurance is not going to cover that bad work. Now, insurance will recover the result of bad work. For example, we had a client, subcontractor came to work over the weekend on a wine cellar, hit a sprinkler line.
Yeah.
And there was nobody there for the entire weekend, flooded the brand new house, right? They didn't cover that he, hit the sprinkler line, but they did cover the flooded house, right? So that's the first thing is that insurance is not going to cover bad work, but they'll cover the result of bad work. And so normally when you get sued a breach of contract, insurance is not going to cover it. But most wise construction attorneys will also sue you for negligence, right? And so in the lawsuit, they'll breach a contract, yada, yada, and also have this claim for negligent, that you acted negligently, meaning not on purpose, and then something bad happened. Now, the negligence will trigger your insurance to defend you, right? But a couple of things on that and what contractors don't understand. All right, so they sue you for negligent. You have a decision if you want to turn it over to your insurance. So you get together this whole big package of how you're right and they're wrong, and you turn it over to your insurance company. And they don't even look at it.
They just say no.
Well, it's not that they don't say, they just say no. The insurance company, once you turn it over to them, it is in their authority to settle or not. And they're evaluating risk, right? And cost. It is going to be easier for them, even if you're right 100%, to write the other side a check for some amount than to fight the court case, even with all your correct evidence.
But are they going to defend me? Or they're just paying out this claim?
Well, they're going to defend you, or they're going to pay whatever's cheapest.
But what if I'm owed money?
And that happens all the time, right? And so we just had a case like this, right? The insurance. So our client did foundation work for a storage unit. I mean, they were suing, and then so they were owed $67,000. They filed a lien. The owner sued them for defective work, and to be honest, right, the concrete was breaking at 5,000 psi. Hugely above the $3,000 that was cried. There was nothing wrong with it.
The 3,000 PSI.
Correct.
Because typically it's 3,000, right?
Correct, but it was breaking even higher than that. So the foundation was good. But they had all this other list of complaints they didn't get. They were being countersued for $600,000. So we stayed in the case to handle their lien claim of $67,000. The insurance came in to defend the $600,000 claim, right? And so they went to mediation, and the insurance actually ended up paying the other side $85,000, and our client got nothing, right? But what was the alternative? She would have had to pay us $150,000 to go to trial to get the 67 to prove, and also prove at the same time that it wasn't defective. And in that case, they had let their entity expire, so they were on the hook personally. So the best business decision they could make was let the insurance company pay out and then not get their money. Unfortunately, that does happen. But in that situation, it sucks, but it was the best outcome that could have been hoped for. They didn't have to pay the $85,000. They did have to pay us on a subscription. But the amount of hours that case took, I think they ended up paying us like $75,000, and it would have been over $200,000 if they had to pay our actual bills.
So if I turn over my lawsuit to the insurance company, does my deadline change to file an answer?
No, it does not. And so what usually happens is like somebody gets sued, they'll bring it to us. We'll file the answer because you don't want to get a default judgment. And then we'll have the discussion. Okay, do we want to turn this over to our insurance? What does that look like? And then we'll help them file the claim. And it's not uncommon the first time you file the claim to get a denial letter, right? And then we go back and forth, we fight the insurance company, and we get them to pick it up. But having insurance and waiting for them to file an answer does not extend your deadline. So usually best practice is go see a construction attorney, have them review the stuff. Let's talk about insurance, but let's still file your answer timely.
So how soon should I contact an attorney if I've been sued?
As soon as possible. You know, we're going to want to get evidence together. We're going to get everything together, and we want to make sure we don't miss that answer deadline. That is so important, right? And plus, if you don't have a relationship with a construction attorney, you're going to have to go find one, right? And I highly recommend that you find a construction attorney, somebody that does just construction, right? Because there's lots of attorneys out there that do personal injury or things like that, yes, they're lawyers, but it's just like doctors or specialists, right? You want somebody who knows what a change order is, how the pay draw schedule works. Somebody who does PI or wills and estates is not going to understand the construction industry. Like the law may be similar, but how the construction industry works is so different than any other industry. And really having a basic, they will miss things that could protect you if they're not a construction attorney.
So let's say I got sued and the person that sued me or their attorney's calling me. Should I talk to them?
So this is kind of tricky. If you've gotten sued, you don't want to talk to them at all, right? You want to hire an attorney because you don't want to say something the wrong way or admit something that you shouldn't be admitting, but before the fact that before you get sued, I highly recommend, before lawyers get involved, if there's an issue, you reach out to the other side and try to resolve it on your own, if possible, right? And sometimes that looks like you paying or discounting your bill, even when you think you don't have to. I'd rather have you pay something up front and be uncomfortable and it sucks than you being on the back end and saying, I wish I would just paid the $20,000 in the beginning because this has taken 2 years of my life, cost me $50,000. Litigation process is stressful.
What does a litigation process look like after filing an answer?
So it can go multitudes of ways, right? And so after an answer, what usually happens is we file an initial disclosure that basically says, hey, here's what the other side's going to send us theirs, why they're suing you. We're going to say why we're not responsible. And then it kind of depends on the case, right? But then we'll go into the discovery period where each side gets asked for documents. We may or may not take it depositions. But you're going to have to turn over documents you don't think are relevant, right? And I'm going to be all up in your business asking for all your stuff, and you're going to ignore me, and that might hound you down. It's going to be very stressful. And if they want to take your deposition, they can do that, right? And so then you got to ask her the other side's questions. And the thing I learned over time is that, yes, you think the story is one way, but I promise you the other side has a different story, and any good attorney can twist what the story actually is or what it should be. And so we go through discovery, and then after that, what we usually do before we go to trial is mediation, which is a chance to try to settle with the parties agreeing before it goes to an actual trial, where at trial, a final decision is made either by a judge or an arbitrator. And it's not what you think. I promise you. It is highly stressful.
So the number one question that we always get, do I have a good case? Where in this process do we kind of see both sides and kind of educate them and say, here are the facts. This is where you stand.
Right. So ethically, no attorney can tell you a guarantee or you have a perfect case, right? And so I can take what you have and say, this looks pretty promising. Yes, I would think it would be worth moving forward, right? Especially like if you get sued, if you have any counterclaims, you're going to want to bring those, right? If you have any way to sue the other party. But really in the discovery phase, we're going to see what everything is, right? And so the legal side of a court case is very different than what it feels like, right? So one party feels that they've been wronged and that they're right and they should win. What that actually looks like is there's very specific elements that have to be proven in court, right? Do you have a contract? Is it signed? Did one party breach it? What is evidence of that? What were the damages and how do we prove damages? So it's not just I'm right, you're wrong. There are very specific things that have to be proven. And so what we do, like when your case first gets started, is we make a case strategy outline that is based on the questions that will be asked to the jury if you go to trial. And so we outline that, like, here's all the things we have. Here's some of the things that we would like to have. Do we have these things, or where can we go get them?
Let's talk about our fees.
Yes.
What do we charge?
So it depends, right? The client can pick. When you've been sued, I highly recommend our litigation subscription, because regardless if, there's 20 hours, 50 hours a month, you'll only be billed the same flat amount. And usually if you're a defendant, it's $5,000 a month, billed $2,500 twice a month. And that, when you're the defendant, it is highly worth it because we're going to get discovery requests. We're going to have to go to depositions, unless you're just going to turn around and pay them, you're going to be in the lawsuit for a while. I mean, there's no easy way out of when you've been sued, right?
You're at the point of defending yourself constantly.
Correct. It's helpful if you have a counterclaim, but
why wouldn't I have a counterclaim?
Well, so say you're a contractor and you got sued for defective work, but they paid you everything, right? What are you going to, there's no real counterclaim that you can have because they've paid you everything. And now they're saying the work you did was bad. There's really, like, if they didn't pay you everything, then we can have a counterclaim for the money that you're owed. But if they did.
I think that's the sucky part for a lot of clients because they're like, I didn't do bad work. Now I'm being sued. I have to pay an attorney to defend myself. And I don't get anything back.
Yeah, exactly. The best you can hope is not to pay them anymore, unfortunately, unless we can find something else that happened. But usually there's no hope for a counterclaim.
How would insurance cover that?
Yes. I mean, the insurance will cover the defense of the lawsuit, potentially. It would not cover any counterclaims going forward.
But at that point, I don't have any, so
Yes.
we got to just defend ourselves.
Exactly, and that's why the
I think
subscription.
that's right, the subscription. But I think that's what a lot of issues with clients, that they don't realize that. But I didn't do anything wrong, so they just ignore it.
And that's the problem, is that, yes, you didn't do anything wrong, but it takes a lot to prove that, right?
Right.
And so, like, one of the basic rules in any cases or breach of contract cases, you've got to prove damages, right? So the other side has to prove damages. You got to say that they didn't have damages. And in order to do that, we need expert testimony, right? So in a lot of cases, like for us, our clients are in the construction industry, so we can designate them as an expert. But sometimes you have to hire outside experts, which then costs even more money. You know, like, yes, I'm a contractor, but I'm not an engineer, and this is an engineering issue, so I need to hire an expert engineer to say that, yes, this is right or not. And that's even more money that has to be spent.
Got it. All right. So subscriptions.
Subscription litigation is the way to go.
That's what it is.
Especially if you've gotten sued. If not, I mean, we still offer the hourly method. I can tell you with most of our clients very quickly that start on that, switch to the subscription, because we're talking about $10,000 or $12,000 a month in bills on a defense case easily.
How would somebody get that information from us?
So reach out to us on our website, thecromeslawfirm.com, or they can give us a call, 713-715-7334. And thanks, guys, for listening to the show.
Bye.